I know with Second Amendment rights, and we are honored and privileged. We even had to wait. He hurt his back a little bit back, and we said, we'll wait, we'll wait. So we have him here today, and I couldn't be any more thrilled. So thank you very much.
Thank you, Representative Stehr.
Absolutely.
Good evening, everyone. How's everyone doing? Good. Glad to see all of you out here tonight this evening. I'm going to start out going over a little bit about myself, as well as introduce two of my colleagues who are here with me tonight. I have never been said to be soft-spoken, so if at any point in time any of you can't hear me, just let me know. Happy to raise my voice. I don't think we have a PA system here, so it'll just be me raising my voice. Also, so you know, we're going to go through a lot of information tonight, so all of you should have one of the handouts that looks like this. This is the seminar handout that I utilize when I do a 4-hour firearms law seminar. And I know what most of you are thinking. There is no way possible this guy can get up and speak for 4 hours about the firearms laws here in the Commonwealth. And yet I can tell you, in my decade plus of doing these types of seminars, I have yet in 4 hours to get through the material that's in this handout. And this handout only generally covers the laws that apply to you on a daily or basis. It doesn't deal with more unique issues, things that maybe apply to you on a monthly or yearly basis. I could honestly do probably a day and a half going over all the state and federal firearms laws that apply to us. That's how complex these laws really are, and that's why I designed this handout as a self-study guide. As you'll see, if you look through the materials, it really does list for you what the particular issue is, where you can find the information, what the statutes or cases are. At this day and age, now that Al Gore's invented the internet, you can pretty much just go on Google, plug in the case name or the statute, and it'll pull right up for you if you want to verify it yourself and see what it actually says. So just keep all of that in mind as you go home. I know we're going to give you a lot of information tonight, probably a lot more than what you're going to be able to retain, even though we're doing a much shorter presentation here tonight. So if any of you thought you were coming for the 4-hour one, surprise, it's not. You're not going to be here until 10 o'clock tonight. But I do recommend, if you ever have an opportunity to attend one of the 4-hour ones, to do it, because you'll get a lot more information during it. Tonight, we're going to go over open and concealed carry, as well as use of force. I am happy to take questions as we go through the materials. The only request I have is that you keep any questions to the particular topic we're discussing. So if we're discussing open carry, please don't ask a question about concealed carry. We will get there. And likewise about use of force. So just keep all that in mind. At the end, if we haven't gotten to a particular topic or issue that you have a question about, please feel free to ask. I love playing Stump the Chump. All right, so bring all your best questions. And with that, for those of you who don't know me, my name is Josh Prince. I've spent my entire career defending our constitutional rights at the state and federal courts. I am most well known for my Second Amendment advocacy, but I've handled all forms of constitutional issues at the state and federal level. I was at the tip of the spear fighting many of the COVID mandates. Many of you are probably unaware that the original COVID mandate actually forced the closure of all law firms so no one could challenge the executive fiats. I was the attorney who filed a special petition with the Pennsylvania Supreme Court, referred to as a King Bench application, where you basically asked the Pennsylvania Supreme Court to immediately hear a case instead of it basically trickling up from the lower courts, because the issue is of such paramount importance. Within 24 hours of filing that King Bench application, former Governor Wolf had a first-of-a-lifetime epiphany, found law firms to be essential, and allowed to reopen. We use the same mechanism to get federal firearms licenses. Your gun dealers reopened as well. So, as I said, I have a lot of experience in all of the state and federal courts defending our rights. With regards to firearms law matters, pretty much if it involves a firearm, we handle it. A lot of what we do for individuals is situations where they may get erroneously denied by the Pennsylvania State Police. Believe it or not, it happens with great frequency that someone gets denied who is not a prohibited person. We also deal with licenses to carry firearms. We're going to talk a little bit about those tonight in relation to concealed carry. It could be a situation where someone gets erroneously denied that license to carry, or it could be their license to carry is revoked. We also deal with specific issues dealing with firearms in estates, may use special devices like gun trusts or things of that nature. There is just a breadth of area to firearms law when you really delve into it. We also represent a bunch of gun clubs, gun ranges. They can have issues, everything from what we refer to as an escapement issue, where a projectile leaves the range, to where they need to institute specific bylaws for being a nonprofit gun club or potentially waivers. And then, of course, we also represent gun dealers, your federal firearms licensees, and that who can have issues with ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or customer issues. There's a million and one different possibilities. Practicing in firearms law really takes you into every area of the law that exists. So with that, I'll let Dylan Harris with my firm do a little bit of an introduction about himself.
Hello, everyone. Thank you all for coming out tonight. Like Josh said, my name is Dylan Harris. I cover a lot of the same types of law and issues that Josh does, so I won't run through those again. In addition to some of those things he already mentioned, we also represent individuals in relation to concerns or issues they may have in relation to game law. So hunting, if you have hunting license revocations or citations, those kinds of things we handle as well. And in addition to some of the Pennsylvania state law concerns Josh talked about, we handle the federal side issues with FFLs and gun dealers and individuals who are having federal firearms law issues anywhere in the country. In addition to that, Josh and myself are both also licensed to practice in Maryland, so we handle all of the same issues in Maryland. And as many of you are likely aware, Maryland is not quite so friendly as we are here in PA, so we keep plenty busy over there also. But I expect for most of you, that's not probably super important tonight. With that, though, I'll turn it over to Kevin, who will introduce himself, and then we'll get the show on the road.
Hi, everyone. I'm Kevin Fenchak. I don't really have much to add. I sort of do all the same stuff that they do. I've been with the firm for about 6 months now, being taught the ropes on the type of law that we practice. That's really all I have.
All right. So with that, I'm going to start with one topical area that's a little bit beyond the scope of the three topical areas I mentioned, and that is the frequency with which people get denied and become prohibited as a result of misdemeanor convictions. A lot of people believe that in order to become a prohibited person, you need to commit a felony, or some people believe a violent felony. So that's actually not the case. Here in the under federal law, as long as you are convicted of a crime punishable by more than 1 year in jail, you are prohibited. Oh, okay. Oh, we got a PA system. Cool. All right. So as I was saying, under federal law, and you'll actually find this information on page 6 of the handout, a misdemeanor can be prohibiting, and frequently is here in the Commonwealth. Most people are not aware of that it is not just felonies or violent felonies that can prohibit someone. So what federal law says is if you are convicted of a crime punishable by more than 1 year in jail, you are prohibited. Now, federal law goes on to define what constitutes a crime punishable by more than 1 year in jail, and basically says it includes any state law offense of a misdemeanor nature that can be punished by more than 2 years in jail. So what that means is any misdemeanor of the first degree here in Pennsylvania will trigger that federal prohibition. So what types of egregious crimes are those? Well, theft generally between $200 and $250, depending on context, will be a misdemeanor of the first degree. Don't get me wrong, $250, it's not money you find in the street, but it's also not grand larceny to strip someone of a constitutional right in relation to. Generally, a second DUI will trigger a misdemeanor of the first degree. And there are a lot of other misdemeanors that will trigger that prohibition. And when we do a 4-hour firearms law seminar, we go through all those different situations where you can quickly and easily trigger those prohibitions. Why I'm telling you this is if there is anything in your background whatsoever, you want to make sure to check with an attorney who is competent and knows what they're talking about, because what we frequently see is individuals who are unaware that their past history prohibits them. They attempt to go purchase a firearm and are denied. And they're like, why am I being denied? And they find out that it's because of a misdemeanor crime that they would have no idea would have triggered that prohibition. And then next thing they know, they're being prosecuted for it. And we have story after story after story of individuals who either asked their attorney whether they were prohibited, and they said, oh, no, nothing to worry about, or who just figured, hey, look, this is a low-level misdemeanor, I shouldn't have to worry about it, attempt to go out to purchase. Maybe even the gun dealer says, hey, yeah, don't worry about it, just fill out the form, check no, and if you get denied, we'll let you know. And next thing they know, they're being prosecuted. So be aware of that. So with that being said, the other one issue that I want to talk about is our definition of loaded here in the Commonwealth. And you'll actually find this, it starts on the very bottom of page 4, just with the word loaded, and then on page 5 actually goes over the definition. So what I'm going to do is I'm going to read you the definition, and then I'm going to actually explain to you why it's so important and why we actually had to enact it here in the Commonwealth. So in 2014, we enacted this definition as a part of House Bill 40, and what it says is loaded is now defined as if a magazine is inserted into a pouch, holder, holster, or other protective device that provides for a complete and secure enclosure of the ammunition, then the pouch, holder, holster, or other protective device shall be deemed a separate compartment. Why is this important? So what was happening is you'd have an individual who, let's say, has their AR-15, no round in the chamber, no magazine in the gun, who places it into a soft case. And on the outside of that soft case, it has zippered or Velcro compartments. And they would put a loaded magazine into that zippered or Velcro compartment. They would be going to the range. They'd get stopped. They'd violate Josh's rule number 1. They'd speak with the police. They'd violate Josh's rule number 2. They'd consent to a search. And law enforcement would find in the trunk this soft case with a AR-15 with no round in the chamber, no magazine in the gun, just loaded magazines on the outside of that soft case in those zippered or Velcro compartments. And they were charging the person with having a loaded firearm in their vehicle. Not only were they charging them with that, they were successfully getting convictions for it. Now, I think we all in this room would say that's like 3 levels away from being loaded, but yet they were successful. So when we enacted our Stand Your Ground doctrine here in Pennsylvania in 2014, we also included this definition of loaded. So now in that situation, it would not constitute the firearm being loaded. So as long as you have that loaded magazine in an outside zippered or Velcro compartment, that is a separate compartment and results in it not constituting it being loaded. So, yes, sir.
Pocket.
So as long as it's a complete and secure enclosure. Now, since we enacted that statute, there hasn't been any case law as to what constitutes a complete and secure enclosure. In fact, even with Velcro, there arguably could be an argument that because it's just a flap and on the sides, it's secure, but is it complete?
Yeah, like a front pocket without a clasp or a button or a zipper.
Right, and so then it's more the question of, is it secure if it's not sticking out? And that's something I honestly don't know. But again, we haven't had that issue. Now, there are legal doctrines where something is not clear that, say, in a criminal matter, it has to inure to the defendant's benefit. So we have the vagueness doctrine and several other doctrines that come into play that could be argued, but that's a defense to prosecution. But again, since this has been enacted, I am unaware in the entirety of the Commonwealth of anyone who, was arguably complying with this provision being charged and having the force to defend against and argue what constitutes a complete and secure enclosure. But it is something to be aware of, because a lot of people in this Commonwealth, especially in more northern parts, still believe that you can have a loaded rifle in your vehicle. Let me try turning this on. See if that works. I'll turn it on, back on. That you can have a loaded rifle or shotgun in your vehicle, and that's actually not the case. Even pursuant to a license to carry, and again, we're going to talk about that in a little bit, we can never have a loaded rifle or shotgun in our vehicle because the General Assembly believes we will have to poach Bambi. And that's literally in the debates when they enacted this provision, that's why they have that. So be aware of it. Also, for any hunters in the room, you probably are aware just leaning a loaded rifle or shotgun up against the vehicle is going to result, if a game warden sees you, in revocation of your hunting privileges. So be aware of that. It does come as a surprise, as I said, to many people. So with that being said, let's talk a little bit about open and concealed carry, and then we'll go on to use of force. So if you turn to page 12, you'll see some information about open carry. So what I am doing here tonight is open carry. You can easily see the firearm on my hip. What I usually tell people in a situation, if I'm not carrying openly or that, as a demonstration, is think of your old school beat cop, where the firearm is on their hip, it's easily visibly displayed. That is what open carry is. Now, we have case law, including from the Pennsylvania Supreme Court, that open carry is lawful throughout the Commonwealth, with the exception of in Philadelphia, without a license to carry firearms. The problem is we have a very draconian transportation law. And I think it'll probably come as a surprise to many of you that if you do not have a license to carry firearms, you can only go to and from, and directly to and from, very limited locations. So if I don't have a license to carry, I can only go from my home to the gun range and back, from my home to my gun dealer and back, from my home to my business and back, from my home to my hunting camp and back. And that's it. Grocery store is not listed. Walmart's not listed. The mall isn't listed. None of the areas or different types of businesses that you would frequent are listed there. And what that means is if you do go to one of the locations not specified there, you violated the law. And even if you do go to one of the locations specified in 6106, but don't go directly to or directly back from, you violated the law. And guess what a violation of that law is? Misdemeanor of the first degree, which means you will be federally prohibited for the rest of your life from being able to purchase or possess or utilize firearms and ammunition. Now, I know what a lot of people say. Josh, come on. It's not likely that they're going to figure out that I didn't go directly back from the range to my house. You know, if I go to the range, put some lead down range, build up an appetite, and decide to stop at the Burger King and get some food on my way home, who's ever going to find out about it, right? Until you're pulling out of that drive-through and you get T-boned, your trunk pops open, police come, and next thing you know, they're asking questions. Hey, I see those rifle cases in your trunk. Do you have your license to carry firearms? Well, no, none of them are loaded. I don't have any loaded firearms in the vehicle. Doesn't matter. You just violated the law. Now, you may be thinking, oh, okay, he came up with a hypothetical. You know, anyone can come up with a hypothetical of any way in which a law can be violated. Well, let me give you two real-world examples with alternate outcomes from different areas here in Pennsylvania. So the first comes from Philadelphia. So you probably already know what the outcome is there. Individual goes to the range. At the range, he's practicing his draw. He has his holster on his hip. He's practicing his draws. And on his way home, remembers that earlier that day, he had called in his prescription to CVS. And CVS is literally directly on his route home. The only deviation he needs to make is making a left into the parking lot of CVS on his way home. So he pulls into the parking lot, goes back to the technician, gets his prescription, it just about hits the front door, and by all accounts, it's something out of a movie. You got squad cars flying up, cops jumping out, guns out. Where's the gun? Where's the gun? Where's the gun? You say, what are you talking about? Where's the gun? Where's the gun? Where's the gun? What are you talking about? They realized that he doesn't have a gun on him. But what had happened was the technician saw an empty holster on his hip, called him in as a man with a gun, and the police responded. There was no dispute by the Philly PD that all of his firearms were in separate compartments in his trunk. His ammunition and firearms were in separate compartments, nothing constituted loaded. But he violated Josh's rule number 1, he spoke to the police. He violated Josh's rule number 2, he consented to a search of his vehicle. And then police said, okay, can we see your license to carry firearms? And he says, I don't have one. He was convicted of that and lost his Second Amendment rights, arguably for the remainder of his life. Differing situation in Northampton County. Individual is on the way to the range, gets a call from a close family friend. She's a victim of domestic violence. She lives very rurally, is trying to get out of the home. Her partner took the keys to the car and has been threatening her. She called 911. She's in a jurisdiction where it's the state police. They responded to her that they're only 55 minutes out. She's trying to get out of the household. She doesn't know what to do. She calls this individual. We'll call him Jim. He's a close family friend. He says, listen, I've tried calling the police. Tommy's beating me up. I need to get out of here. I don't know what to do. He's taking the keys. Can you come pick me up? Sure, no problem. Swings by. She jumps in the car. It's actually a van. And at that point, a officer from a neighboring jurisdiction decides to come over because he hears that the PSP is 55 minutes out. He knows Jim. Jim is actually a paramedic in the local community. Everyone knows Jim. Everyone loves Jim. He comes up to the window and says, hey, Jim, what's going on here? Jim says, listen, she's a victim of domestic violence. She wants to file a report. She called 911. The PSP says, I know, I heard they're 55 minutes out. That's why I responded, even though this isn't my jurisdiction. He says, okay, well, let me just stop you there, Jim. Is there anything that I need to know about in this vehicle? That's one of my favorite law enforcement questions ever, because I have no idea what this law enforcement officer thinks they need to know about. But Jim says, well, I have my firearms here in the vehicle. I was headed to the range. I got the call. I came over. Oh, that's fine, Jim. Can I see your license to carry? Oh, no. I don't have anything loaded in my vehicle. No, Jim, I still need to see your license to carry. Oh, I don't have one. His police chief directs the officer to file charges against Jim. And we go to the preliminary hearing. And for those of you who are not familiar, at a preliminary hearing, the Commonwealth has to establish that it's just likely that a crime occurred. Any defenses that you may have to prosecution or anything of that nature goes out the window. They don't care about it. You can't introduce it. It's just, is it likely that a crime occurred? This magisterial district judge, when he hears the background to this, is so incensed that the police chief and the department would bring charges in this situation. He says, I understand what the letter of the law is, but clearly this was not what it was intended for. And he said, this is a bogus charge. And he threw out the charge and told the police if they ever bring these types of bogus charges in his court again, they'll never get another warrant from him. So it's the right outcome, but legally speaking, that shouldn't have been the outcome. Honestly, those issues, Jim had arguable defenses that he could have utilized at the Court of Common Pleas, the next step up. But this judge was so incensed with the fact that he should have never been charged to begin with that he decided to dismiss the charges, and thankfully, they never refiled them. But that's how easy these types of situations can arise. Even when you're trying to do the right thing, even when you're trying to be the good guy,
helping someone out in a really bad situation, next thing you know, you're the one being criminally charged for doing that. So that's another reason why I tell everyone who's eligible, always go out and get your license to carry firearms. It's extremely important. Now you'll see on page 12 that I also have a citation to Commonwealth versus Hawkins. It's a Pennsylvania Supreme Court case where the Pennsylvania Supreme Court said that it does not constitute reasonable suspicion of criminal activity just because you see someone with a firearm. So someone just walking like I am, openly carrying, doing nothing more, that is not reasonable suspicion of criminal activity. You'll see a little later on in the materials, I have a newer case, Commonwealth versus Hicks, that actually went up before the PA Supreme Court only several years ago, and I was pretty much assured that the PA Supreme Court was actually going to overturn Hawkins. And the background to Hicks, it's actually an unusual case. What occurs is Hicks is in Lehigh County, and he stops at a gas station. And what's so unusual about this case is the PA Supreme Court, it gets all the way up to the Supreme Court, and the court says, we're not sure on the record of exactly what happened, although there was apparently a video. We don't know whether Mr. Hicks stopping at this gas station, a wind gust came up, blew up his shirt, and his firearm was displayed, or whether in talking with the person next to him at the gas pump, who he seemed to know, he kind of raised his shirt up to show his gun that maybe he had got new. It was all amicable, and then walked away, went into the store, paid for the gas, gets in his car, drives away, and police stop him because there are cameras on the street, and one of the camera technicians just happened to see this shirt come up and saw a gun and told police to respond. So the sole basis for the police responding and pulling over Mr. Hicks was there's a man with a gun, basically. Not that he threatened anyone, not that he did anything with the firearm, just because they saw a person with a gun. He filed motions to basically suppress everything at the Court of Common Pleas. He was represented, unfortunately, by the Public Defender's Office that did a horrific job of representing him. And then we saw the Public Defender's Office actually appeal it up to the Superior Court. The Superior Court affirmed that there was no basis for suppression here, that the police stop was lawful, and the Public Defender's Office appeals it up to the PA Supreme Court. And the PA Supreme Court agrees to hear the case. And I had seen the work product that the Public Defender's Office had done at the Superior Court, and I knew it was not going to be pretty for us. And as I said earlier, I fully expected that the court was planning to overturn Commonwealth v. Hawkins. So I actually had a number of state representatives and other Second Amendment organizations that wanted me to file something what's called an amicus brief. It's a friend of the court brief. And we basically reviewed all 50 states' laws and case law regarding whether just merely seeing a firearm openly displayed constitutes reasonable suspicion of criminal activity, as well as all the federal case law there. And about 56 pages later, come to the conclusion that there's no support that just merely seeing a firearm constitutes reasonable suspicion of criminal activity. Believe it or not, even in New Jersey, they had case law that merely seeing someone with a firearm did not constitute reasonable suspicion of criminal activity. And when the Pennsylvania Supreme Court issued their decision, they basically reaffirmed Hawkins, saying that merely seeing someone with a firearm openly displayed without anything more does not constitute reasonable suspicion of criminal activity. So they got to the right result, thank God. Now, the other thing to be aware of with regards to open carry is you can never get in any mode of conveyance. And mode of conveyance is extremely broad. Think as broadly as you can. Being on roller skates is a mode of conveyance. Being pushed around in a wheelbarrow is a mode of conveyance. Being on a horse, being on a tractor, being in a car, being on a bus. All of those things are modes of conveyance, because it does not matter whether or not they're motorized. And that's extremely important to be aware of, because a lot of people will think, oh, I'm openly carrying. You can openly see that I have a firearm on my hip and I'm on horseback, so there's no problem. It's not true. You need a license to carry in order to carry a loaded handgun in any mode of conveyance. And I can't tell you the amount of people that have been prosecuted because of their misunderstanding of the law in that regard. There was an individual who was actually out front on his own lawn, mowing his lawn on his tractor, and he thought he's open carrying. He doesn't need a license to carry. Police see him, charge him with carrying a firearm without a license. Anyone want to take a gander at what a conviction for that is? Either a misdemeanor of the first degree or a felony of the third degree. It's a felony of the third degree if the person wasn't otherwise eligible for a license to carry, and it's a misdemeanor of the first degree if they were. So either way, they're going to be prohibited for the rest of their life as a result of that. Doesn't make a lot of sense, does it? So with that, moving on to page 13.
That's even on their own property?
So the question is, that's even on your own property. So yes, unless it's in your house. In your house, in your business, your own business, you can have a firearm concealed on your person or openly displayed on your person, loaded, without any issue. But as soon as you step outside of your house, even on your own front lawn, or outside of your own business, even on your front sidewalk or that, at that point you needed a license to carry firearms. And there was there's a case, and I forget what county. Do you happen to remember the county where the individual, he was in his own apartment building? And I forget, it's a case that recently came about where an individual was in his own apartment and that he rents out. It was currently unrented, but there had been a number of break-ins recently in the area. And he was actually staying in the house to protect it. Someone breaks in at 2 a.m, he ends up using lethal force. And now the district attorney has not only charged the individual who broke in and who he shot, but also him, contending that it wasn't his house. I mean, that's how ridiculous some of these things get. And that's why everyone should always have a license to carry if you're eligible. So let's move on and talk about licenses to carry. Sorry, I've been talking all day and I'm apparently losing my voice already. So you'll see there on page 13 the mention of Commonwealth versus Hicks about 2/3 of the way down. So if you do want to see that decision, there's a link there for you to be able to check it out. Now, in relation to a license to carry, if you are not otherwise prohibited, and I'll talk about that in a second, would apply at your sheriff's office, your county of residence sheriff's office. The cost is $20. Now, some are now allowing you to submit your application electronically through a system called Permitium. Permitium charges a $5 convenience fee. So if you decide to use that online service, it'll actually be $25 instead of $20. But if you decide to take your application down to the sheriff's office, it's $20 for 5 years, and it's state-issued ID. It's good throughout the Commonwealth, including in, as I call it, Philadelphia. I know there's a lot of misinformation about that, thinking that Philadelphia is something special, but it's not. And it gives you so many exceptions under the law that it's a no-brainer. It's basically the best form of insurance you can get against prosecution here in the Commonwealth. Because if you have that license to carry, guess what? That transportation law I told you about, 6106, doesn't apply. You don't have to go directly home from the gun range. you don't have to go to a specified location. You can transport that firearm anywhere. Yes, sir.
With that electronic thing, how do they handle the photograph?
So the question is, with Permitium and submitting your application electronically, how do they handle the photograph? You're still going to need to end up going to the sheriff's office once you're approved to get your photo taken. Now, one of the things I've actually been pushing for, and I'm trying to get the Pennsylvania Sheriff's Association to push the PSP for, is to basically take your photo from your driver's license. Believe it or not, down in Maryland, if you want to get a concealed carry license there, you can submit your own photograph. You don't need to go in person. Once you've passed all their requirements in that, you submit in your own photo and they just put it on the license. I think that should be here in Pennsylvania the same way, or at least take it from your driver's license or other state-issued ID. The PSP is already tied in the PennDOT driver's license system and state licensing system to their network, in essence, where they could grab that photo and include it right on your license. But as of right now, yes, you are always going to have to go in at least one time to the sheriff's office. And do be aware that technically speaking, the sheriff has 45 days to issue a license to carry. Now, in many counties where we have constitutional sheriffs, that as long as the Pennsylvania State Police's background check system is up, they'll process your application and issue your license right then and there. But legally speaking, they do have upwards of 45 days to process that application. And one of the reasons I bring that up is a lot of times I'll do these seminars and there'll be a young lady who says, you know, I just don't feel comfortable carrying a firearm right now. And I said, that's perfectly fine. No one should push you to carry a firearm if it makes you uncomfortable. But hear me out. Go get your license to carry anyway. Because maybe you don't feel comfortable concealed carrying a firearm, but if you're going to do any target shooting or anything like that, you're still going to be going to and from the range. Get all the protections that having that license to carry gives you. Secondarily, if a stalker comes into your life, you already have an ability to immediately carry a concealed firearm for your protection. Whereas if you don't, and you now have to go and apply, and you live in one of those jurisdictions like Philadelphia, where they take the full 45 days to issue your license to carry, well, guess what? You're going to be waiting that time if you unfortunately live in that jurisdiction. So that's why I think it's really important for everyone to go out who's eligible to get your license to carry. And so you know, as a general rule of thumb, if you can purchase firearms, you're eligible for your license to carry. The one exception to that is if you've ever been convicted of any drug offense. So even possession of a minor amount of marijuana that would not in perpetuity prohibit you from being able to purchase, possess, utilize firearms and ammunition, it will prevent you from being able to get a license to carry firearms. So be aware of that because it's an important issue that many overlook. Now that being said, it's rare for someone in relation to a license to carry firearms application who gets denied to get prosecuted over making a false statement on that application. It can happen, but it's generally not going to be in relation to someone who has a minor prior drug offense. So keep that in mind. But beyond that, as long as you're 21 years of age or older, you can apply for the license to carry. Also, so you're all aware, we actually have litigation pending and a new case about to be filed involving whether individuals between 18 and 21 should constitutionally be able either to get their license to carry or be exempt from the transportation laws and other laws that would otherwise apply to them if they had the license to carry. So we actually were successful in front of the Third Circuit Court of Appeals, which is the federal court that covers Pennsylvania, in them ruling that 18 to 20-year-olds have Second Amendment rights. Believe it or not, the Pennsylvania State Police previously argued that 18 to 20-year-olds do not have Second Amendment rights. And out of the Western District of Pennsylvania, Judge Stickman agreed with them and dismissed the case. It went up to the Third Circuit, and now, I guess it's probably about 4 weeks ago or so, the Third Circuit ruled no, 18 to 20-year-olds have Second Amendment rights. So we'll be bringing a new action in relation to the inability for those individuals to get licenses to carry. So moving on, I'm going to talk about a couple different places that debunking myths, because there's a lot of misinformation out there about where you can and can't basically carry firearms. So the first is while voting. You'll see there's a blog link as well as a link to the Northampton County website. I had a client who in Northampton County went to vote. He was open carrying, was denied his ability to vote. As a result, now Northampton County on their voter registration page has information that it is lawful to open or conceal carry a firearm while voting, provided it's not in an otherwise prohibited place. And we're going to talk about what those other prohibited places are in a minute. But do understand that there is nothing in the law that prohibits someone, unless it's in relation to a prohibited location, from carrying, whether openly or concealed, a firearm while voting. It's one of the few times, other than doing seminars like this, where I actually will open carry while voting. Usually I only conceal carry, but there I think it's not just a Second Amendment issue, but it's a First Amendment issue. It's political speech. I'm making a statement by open carrying while voting. So to each their own, but do be aware of that. Also, national parks. Since February of 2010, it has been lawful to open or conceal carry a firearm consistent with the state's laws in which the national park is. So basically, any national park here in Pennsylvania, as long as you are otherwise in compliance with Pennsylvania's laws, you may open or conceal carry a firearm in those national parks. Now, the one thing to be aware of is all federal buildings are off limits. So why am I bringing this up? Think about the buildings that you may find in any national park, including a bathroom. Do not find yourself with your firearm in any federal building, because you could be looking at serious federal charges. So beyond that, there's also a myth that it is unlawful to open or conceal carry a firearm in an establishment that serves alcohol. I believe it used to be Virginia, it may have been West Virginia, that had a law prohibiting someone from being able to open or conceal carry a firearm in an establishment that serves alcohol, regardless of whether they had ordered any alcohol. I think that law has since been repealed, but we've never had a law like that here in Pennsylvania. Although I am one who says alcohol and guns do not mix, I can also tell you there is no specific prohibition here in Pennsylvania regarding someone drinking alcohol while carrying a firearm. Now, it's, again, not recommended, but that alone, that conduct itself, is not unlawful. Now, if you do something stupid because you drank alcohol and are carrying a firearm, that's a different story. You can be prosecuted depending on context for all sorts of things, such as recklessly endangering another person, terroristic threats, simple assault, aggravated assault, all going to depend on the context of what has occurred. But just simply imbibing in libations while carrying a firearm is not a prohibiting offense. The other myth that's out there that was put out by sheriffs a long time ago who don't like open carrying is that once you get your license to carry firearms, now you can no longer open carry. That is not true. And in fact, I have a number of clients who want to only open carry, and I always advise them, go out and nevertheless get your license to carry firearms because of those transportation laws and a number of the other protections that having that license to carry gives you. So I can tell you, you do not lose your right to open carry just because you have a license to carry firearms. So let's talk about some prohibited locations. Some are going to be no-brainers. Others may surprise you. So court facilities. Now, we're talking about state court facilities because remember I already told you all federal buildings are off limits. So we're not talking about federal courts, only talking about state courts. They are prohibited locations. However, they must provide lockers for you to be able to lock up your firearm. Each county handles this somewhat differently. So for example, in Chester County, you go in the court, and before you get to security, on the right side, there's a wall of lockers. You basically go put whatever you want in them, whether it's your handgun, pocket knife, you name it, keys. You put it all in there, you take a key, then you go through security. Berks County, a little bit different. You're going to go in, you're going to be right there with a security officer. You're going to say, hey, I have my license to carry firearms, I need a locker. They're going to take you down to the subterranean floor where they have lockers for you to be able to lock them up. We actually had an issue in Montgomery County where the sheriff was telling everyone, no, well not the sheriff, excuse me, the deputies out front were telling everyone, no, we don't have lockers, you can't store them here, they're only for law enforcement, you have to go out and put it in your car. And then we had a client whose car was broken into and firearms stolen, and the Montgomery County Sheriff goes and revokes my client's license to carry. Says he's a danger to society because he left his firearm in his vehicle. And of course I had to explain to the sheriff that his deputies were directing everyone to do that. My client's license to carry was reinstated shortly thereafter. And I understand that there was some training provided there, but I still think there are some issues in Montgomery County. But nevertheless, that's just to explain to you, each court deals with it differently. Also, magisterial district judges also are supposed to have lockers. Now, some counties, they don't. A lot of times what's funny is they actually have lockers and they don't know what they were for. There was actually a situation recently where a client of mine went in to a magisterial district judge's office and said, hey, I need a locker to be able to lock up my gun. And the nice old lady behind the desk says, is that what this locker's for? No one's been able to tell me in my past 25 years what the locker's for. I've had this key on this ring and was told if I ever need to use the locker, but no one's told me what it's for. So again, it's going to be different, but I do know there are some magisterial district judges' offices that do not have lockers. And that's a violation of law. They are required by statute to have those lockers, so be aware. Within 1,000 feet of a school, unless you have a license to carry. Now, we'll talk about on school grounds in a couple minutes because that's a kind of gray area. Right now, we're just talking about those black and white areas that are clearly prohibited or not. But this is within 1,000 feet of a school. This is a federal law, but you're exempt if you have a license to carry. Now, a lot of times I'll have people ask, well, what happens if I live within that 1,000 feet radius? That's okay. There's an exception for you when you're on your own property. But think about how you get to your own property. Do you have to go through that 1,000-foot radius? If so, you're violating the law. And we're not talking about loaded firearms here. We're talking about any firearm, unloaded, just going through that 1,000-foot radius. Also, think about today's society, all the different schools and that exist. Think about going to the range. How many times do you think you go through the 1,000 feet of a school zone without ever thinking about it? Maybe on your way to the range and you don't have that license to carry. Guess what? You just violated the law. And if you're convicted of it, goodbye Second Amendment rights. Go out and get the license to carry. Detention facilities, correctional institutions, and mental hospitals. Now, I don't think any of them come as a surprise to you, but the one issue I do want to mention to you here, mental hospitals. Mental hospitals are not defined under the Uniform Firearms Act. So whether the wing of a hospital that is designated for mental issues constitutes a mental hospital, I can't tell you. What I can tell you is don't find yourself in that mental wing. I'm not saying for your own treatment purposes. I mean, I don't want you to see you there for that either, but don't be visiting someone who's in that mental wing with your firearm. And we will talk about whether hospitals and other private businesses can regulate on their own property in a couple minutes, but as a general rule of thumb, do not find yourself with a firearm in mental wing of a hospital. And then we have Some other ones, open and carrying without a license to carry firearms in Philadelphia, as I mentioned to you before. That is prohibiting, another reason to have that license to carry. Also, you cannot conceal carry a firearm without having that license to carry. I've also mentioned before, you can't ever have a loaded long gun, rifle or shotgun in your vehicle, even pursuant to a license to carry firearms. So be aware of that. Also, long guns on the streets and public property of Philadelphia. So basically in Philadelphia, you can't go anywhere, think about this for a second, without having a license to carry. How many people do you think violate that law? Because you literally could not go to your gun dealer, purchase a gun, and drive that unloaded firearm, let's say it's a bolt action rifle, a Savage 30-30. You couldn't drive that to your home because you would be on the public streets or public property in Philadelphia. That's how insane some of these laws are. And that's another law that we are challenging in our federal action. Private property owners. So no different than you and I, any business that's a private business, private establishment can regulate on their property. So no different than if someone comes over and is reeking of marijuana, or it's just someone you don't like, you can say, get off my property. I don't want you here. So too can any other private business in relation to you carrying a firearm on their property. So be aware of that. I know a lot of people don't like it. There are obviously businesses that cater towards those who carry firearms. There are businesses that say, we would rather you not. Like a lot of times now Walmart says, oh, we prefer you not. They don't say you can't. They'll say, we prefer you not. Be aware of that, because when we talk about use of force, it can matter. If you're at a location where they have a no guns policy and you're aware of it and you're ignoring it, you may no longer be entitled to our stand your ground doctrine. But again, we'll talk about that in a couple minutes. The other thing to be aware of, another prohibited location, is Veterans Affairs facilities. And I know what all of you are thinking, Josh, you already told us multiple times federal buildings are off limits. Correct, but the Veterans Affairs facilities include national cemeteries. Do not find yourself in a national cemetery with a firearm, or you'll be looking at serious federal charges. So let's talk about some questionable places. Possession of a firearm on school property pursuant to a license to carry. So you'll see here that on page 16, I actually have a blog link to the Gosselin decision. I'll give you a little bit of background about the Gosselin case because I ended up handling that case on appeal. So what happens, this happens in Lancaster County. Mr. Gosselin and his son, the night before everything unfolds, are out whittling sticks. And like any good young man, he decides to wear the same pants the next day to school. And while at school, he realizes he has his Swiss Army knife in his pants pocket. And he does what I think every one of us in this room would say is the right thing. He goes up and immediately self-discloses to his teacher, says, teacher, I was wearing these pants last night with my dad, we were whittling sticks. I put this Swiss Army knife in my pocket, didn't think about it, just realized it's in my pants still today. She says, oh, well, we got to take you down to the principal's office. Now, the principal was on vacation, and it was just the vice principal and the superintendent who were there. And this will become important because there are two drastically different stories of what actually occurred next. So they call Mr. Gosselin and say, you need to come to the school immediately. We need to have a hearing about whether to expel your son. They never tell him why they are holding this hearing. They say, you just need to come to the school immediately. So he goes down to the school. See if this is better. So he goes down to the school, and they immediately start a hearing. And they start asking him, are you aware that your son came down here today with a Swiss Army knife? He says, what are you talking about? Well, your son came up to the teacher and told him that he had a Swiss Army knife in his pocket. And
Mine's been off.
Oh, is it all?
Yeah, I've had it off.
Oh, okay. And he says, you know, I didn't know anything about this. Yes, we were whittling sticks last night. And they said, okay, well, our school has a policy. It's a no tolerance policy in relation to any types of weapons that are capable of inflicting serious bodily harm or injury. And he says, well, what are you talking about? Well, you can't have a knife on school grounds. And here's where the testimony diverges greatly. The vice principal says Mr. Gosselin, in the middle of this hearing, pulls out his pocket knife, slams it down on the table and says, are you telling me I'm violating this school policy? The superintendent's story is very different. He says that Mr. Gosselin, as hearing's going on, sheepishly pulls out his knife and says, are you saying I'm in violation of this policy? And when they said yes, he just kind of sheepishly puts it back into his pocket. Now, the vice principal testified that she has post-traumatic stress disorder as a result of this. She testified he never opened the knife, never threatened her with it, nothing of that nature, but she has PTSD as a result of this. Mr. Gosselin didn't have the best representation in front of Lancaster Court of Common Pleas and was convicted. He filed his own appeal because he didn't have money. And I'll tell you what, this is when the Superior Court comes down with its initial determination is the first time that I find out about this case even being up before the Superior Court. And basically what the Superior Court did in a 3-judge panel is 2 judges said, yes, we're affirming the trial court's conviction of Mr. Gosselin. 1 judge wrote a dissent saying, look, I may not like what the statute provides, but he did not violate the statute. And so this is at the point in time, maybe. And actually reach out to Mr. Gosselin through Firearm Owners Against Crime, who make contact with him. He had, as I said before, an inability to be able to pay an attorney, which is why he represented himself. However, his brief before the Superior Court was better than probably 90% of the briefs that I read from lawyers. He did a phenomenal job, but unfortunately, they had voted to affirm his conviction. I asked him, I said, are you willing to let me represent you? I'll represent you free of charge. I want to ask the court to do several things. First, to basically vacate its prior decision. See if this works. Vacate its prior decision, provide me with an opportunity to brief the issue, and to give us what's referred to as en banc reconsideration, meaning in front of the entire court instead of just a 3-judge panel. And Mr. Gosselin was extremely appreciative. He says, I want counsel, I just haven't been able to afford it. So I filed a motion with the court, and to my surprise, because the Superior Court here, I refer to as either the bipolar or the crack court, because you never know what you're going to get out of our Superior Court. It is truly bipolar. And they granted everything I requested. They vacated their prior decision. They gave me an opportunity to brief it and argue it orally, and they agreed to hear it in front of the entire court. And so after briefing the entire issue, and the big issue with the case is the statute says it's unlawful to possess any weapon capable of inflicting serious bodily harm or death on school grounds. Now, that's pretty much everything. But there is an exception or a defense to prosecution that the weapon was either possessed and utilized in relation to a school course or activity, or possessed for an other lawful purpose. What the trial court had done is said that this secondary clause, or possessed for an other lawful purpose, had to be related to a school course or activity. But when you actually look at the language in the statute, it talks about the defense being that it was possessed and or utilized in relation to a school course or activity, or possessed for other lawful purposes. And that there's separate clauses providing for separate defenses. And the Superior Court, en banc, again meaning the entire court, agreed with us. And they actually reversed his conviction, said that here there was no evidence of record that he possessed it for an unlawful purpose. In fact, Mr. Gosselin had testified before the court that the reason he possessed his knife is first and foremost, he's a carpenter by trade. And oh yeah, by the way, he was there out working at the time he got the call from the school to come immediately to the school. He also testified that he has the knife for when his wife packs him cans of tuna and he needs to open them. There was clearly no unlawful purpose. He didn't go there with the knife to cause someone harm, and so the court said that he was entitled to this defense and reversed his conviction. Why did I spend all the time going over this with you? Because it's important to understand that it is a defense to prosecution. So if you have a license to carry, it is arguably lawful to possess it on school grounds. However, the district attorney can charge you and force you to defend against those charges with the fact that you possessed it for lawful purposes. So this ties in to any application for a license to carry. Generally, our laws define that which is unlawful. But in relation to a license to carry, our statute actually says that a lawful basis for obtaining a license to carry is self-defense. So I tell everyone, when you apply for your license to carry, select the checkbox for self-defense, because our law is already acknowledging that that's a lawful purpose. The reason for that is if you would ever, God forbid, be found on school grounds with a firearm pursuant to a license to carry and be charged in relation to it, it makes it easier for us to defend against it when we can point to the fact that you had no unlawful purpose in being on that school ground. And in fact, state law specifies that a lawful purpose is self-defense, and that's why your license to carry was issued, or what your license to carry was issued for. So be aware of that. There is a lot of information on our blog at that article that's linked there if you want more information about it. I'm aware, since the Gosselin decision came down, of just over 100 instances of people possessing different types of weapons, not just firearms, but all forms of different types of weapons on school grounds, where either the officer initially charged it because they were unaware of the Gosselin decision and the district attorney dismissed the charges, or where the law enforcement or district attorney was already aware of the Gosselin decision and never filed charges. So just be aware of this, because it is a sticky situation in the sense that there are no guarantees that you won't be prosecuted. So other questionable places include certain Department of State buildings. Now, this is through a regulation, and there's actually a provision in section 6109 M.3 that says Commonwealth agencies may not regulate, among other things, the possession of firearms. And so this regulation would seemingly be unlawful. However, there hasn't been a challenge to it, and I don't know of anyone who's ever been prosecuted for violating it. Casinos. So before our former Attorney General Kathleen Kane started wearing orange, she was in a situation where I challenged the Gaming Control Board's regulation that precluded firearms at a casino. So this wasn't casinos deciding that they didn't want firearms there. It was a Commonwealth agency, the Gaming Control Board, passing a regulation that no one could have firearms on casino property. And in preparing the challenge, I actually did some research on the crime that occurs, especially in casino parking lots. I don't know why anyone would ever go to a casino, to be honest with you. It's worse than Mogadishu. I mean, when you hear about all these different crimes and that, and I'm writing about them in my letter to the Gaming Control Board, I'm like, if there's any place you need a firearm, it's definitely in the parking lot of a casino and in the casino itself. And what was interesting is the Gaming Control Board basically said, well, we don't know what to do with this we're going to ask the Attorney General to weigh in and tell us whether our regulation is valid or not. And you'll see a link there where you can actually download a copy of the letter that then Attorney General Kathleen Kane issued telling the Gaming Control Board that yes, its regulation was unlawful. And it was very interesting because shortly after that came out, there were a number of casinos in Western Pennsylvania that started advertising as being pro-Second Amendment, carry your guns to our casinos, and they had lines out the door of pro-Second Amendment individuals wanting to go to their casinos. Now, as a casino is a private property owner, they can still regulate you by their own means. It's just that the Commonwealth or a Commonwealth agency can't direct that you can't possess the firearm on those grounds. So be aware of that. Casinos can still, on their own as private entities, regulate your ability to have firearms on their property, but the Commonwealth cannot. Snowmobiles, ATVs, you have to jump through about 5 different statutes, but the long and short of it is basically no different than your vehicle. It's a mode of conveyance, so as long as you have a license to carry firearms, you can have a loaded handgun on your person on that ATV or that snowmobile. Just remember, just like any other vehicle, you can never have a loaded rifle or shotgun on one of them. So we're going to move over to page 18 and talk a little bit about our 2 self-defense stuff. We have both a castle doctrine and a stand your ground doctrine. We're going to talk about them separately because they provide separate things. And we're going to start with the castle doctrine. It may surprise you with some of the limits with the castle doctrine, but we'll get into that, and then we'll move on to the stand your ground doctrine and go from there. So, what is the castle doctrine? Basically, with castle doctrine, it is in relation to not just your home, but also now your vehicle. And that was a result of House Bill 40, our stand your ground doctrine. It applied the castle doctrine to your occupied vehicle, meaning you're in the vehicle at the time the castle doctrine will apply. Well, what does that mean? Well, before we get to what the castle doctrine means, we have to go over some definitions, because this is really where some people may get caught up. So what is the definition of a dwelling? Any building or structure, including any attached porch, deck, or patio, though movable or temporary, or a portion thereof, which is for the time being the home or place of lodging of the actor. So think about that. That's a very broad definition. It can be movable. It can be temporary. So if you have legal right to be somewhere on someone's property and you're in your tent, that is your dwelling for that night. Castle doctrine is going to apply to it. Now you'll see I have some words emphasized there, including any attached porch, deck, or patio. I know how you attach a porch. I know how you attach a deck. I have no idea how you attach a patio, and I have no idea what a patio is. And it's a situation where the General Assembly has not defined what is a patio. Is your front sidewalk a patio? No idea. Is your backyard a patio? No idea. As an attorney, generally when a legislature doesn't define a term like that, we turn to Black's Law Dictionary. Guess what? Black's doesn't define it either. So it's going to be left up to a court to decide whether your backyard, whether your front patio that you contend is a patio, but the judge may say is not a patio, is a patio. So be aware of that. But any attached porch or deck is going to be part of your dwelling. Now, the other thing to be aware of, and this trips up a lot of people, if your garage is connected to your house, attached to your house, it's your house. But if you have a detached garage, guess what? Castle doctrine is not going to apply in your detached garage. Also, castle doctrine does not apply outside of your home, other than in your vehicle. So your front yard, if it doesn't constitute a patio, is not going to be covered by castle doctrine. You're going to end up in a stand your ground situation. And this is important to understand. And there has been pushes in the past years for the General Assembly basically to include the word curtilage. Curtilage has legal meaning basically not just your home, but your meets and bounds. So your entire property line would be included in castle doctrine. But unfortunately, as many of you know, we haven't been real good at holding the governor's mansion over the years, and as a result, those desires and intents to try and pass changes to include curtilage have been unsuccessful. So do be aware of that. Another definition that's important for us to discuss is vehicle. Now, we kind of already talked about this, but here's the actual text. A conveyance of any kind, whether or not motorized, that is designed to transport people or property. So, like I mentioned to you before, if you're in that wheelbarrow, guess what? That's a mode of conveyance. The tractor is a mode of conveyance. Horseback, mode of conveyance. You need to think very broadly, because it doesn't matter whether or not they're motorized, and it doesn't matter whether it's designed to transport people or property. So even the wagon is going to be a mode of conveyance. So, when does castle doctrine apply? Well, an individual is to be presumed to be acting reasonable in the use of deadly force if the person against whom force is used is in the process of unlawfully and forcefully entering, or has unlawfully and forcefully entered, and is present within a dwelling, residence, or occupied vehicle, or the person against whom force is used is or is attempting to unlawfully and forcefully remove another against the other's will from the dwelling, residence, or occupied vehicle. So that's a lot there. What that means is basically if someone has broken into or is attempting to break into your home, you are authorized to use lethal force against them, provided that one of the exceptions does not apply. So what are those exceptions? So the person against whom force is used has the right to be in or is a lawful resident of the dwelling, residence, or vehicle, such as the owner or lessee. So in this situation, if you're just leasing a vehicle and someone comes to take, you can't use basically castle doctrine against them. You can't contend that they don't have legal right to be there. If you have a co-tenant in your apartment, you can't basically contend that you can use castle doctrine against them when they come home. The person sought to be removed as a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the protective force is used. We don't want anyone being able to contend that castle doctrine applies in child exchanges or other matters similar to that. The actor is engaged in criminal activity or is using the dwelling, residence, or occupied vehicle to further a criminal activity. We don't want the gangbanger or drug dealer being able to contend castle doctrine. And then lastly, the person against whom force is used is a peace officer acting in performance of his official duties, and the actor using force knew or reasonably should have known that the person was a peace officer. Makes sense. We don't want people being able to contend that they can use castle doctrine against law enforcement in their actual job duties. Yes, sir.
Being what happened in Arkansas recently, and this is the government that our forefathers wrote the First and Second Amendment about. Somebody shows up at my house at 3 o'clock in the morning, covers up my Ring doorbell, starts kicking my door in. I'm gonna start shooting. Am I gonna be in trouble if I drop them? They made no announcement of who they are.
So that's a big issue with no-knock warrants to the extent they have one. And there have been a number of instances, not here in the Commonwealth, but throughout the United States, where individuals, because of no-knock, no-announce warrants, basically end up using lethal force on law enforcement. And it becomes a jury decision whether they knew or reasonably should have known. And there have been plenty of cases where juries have come back and said, no, listen, you know, it was no knock, no announce. Maybe after they made entry, they announced themselves, but someone's in a deep sleep, waking up, doesn't know what's going on, sees people all dressed in black and guns, and they believe their house is being invaded. A jury can reasonably believe that they had no reasonable basis for believing that it was a law enforcement officer. So it's really going to depend on the circumstances. As I said, as long as someone is attempting to break in or has broken into your dwelling. Now remember, that includes an attached porch, deck, or whatever a patio is. So if they've already come through your porch that's enclosed, they've already entered your dwelling. And if they're kicking in your front door, again, they've already entered your dwelling, and you would be authorized, if you have no reason to believe that they were law enforcement, to use lethal force. Again, it's going to end up likely being a situation where you're going to end up getting prosecuted, and you're going to end up in front of a jury having to explain to them why you had no reason to believe that this was law enforcement. Does that answer your question? Sure. Was there? Yes, ma'am.
If you have a garage and your house and your basement, the basement is a walkout, but there's a cement patio in between that touches both of them. Is that considered a detached garage?
So if you have a walkout basement that has some cement patio or whatever we call it between it and a detached garage, does that mean the garage is detached? Yes, that wouldn't be part of the dwelling in that situation, because it doesn't talk about then attaching something, even if that area space, let's call it, outside of your walkout basement and the garage does constitute a patio, you can't then apply it beyond that patio to the detached garage.
So if somebody broke into the garage,
No. So in that situation, and quite honestly, I know we talk about a lot of these hypotheticals and that, but I'm always going to tell someone, unless you have a family member in that building or structure, whatever the case may be, that you believe is in danger, call police. Let them deal with it. Because the ramifications of having to utilize lethal force, I don't care who you are going to be great. And it doesn't matter even if you don't end up killing the person. We've had clients who intended to kill someone, only maimed them, and it was a minor flesh wound, but you would have thought that individual had taken that other person's life because of the emotional impact. And I don't care who you are, you're going to need psychological counseling for dealing with it. And I'm sure many of you have heard, that the divorce rate's around 50% generally. When you have a situation with someone who's utilized lethal force, they're going to be going through a form of PTSD. And the divorce rate is actually above 80%. Because the spouse who was not involved in it can't understand what the spouse who was involved in it is actually going through. And the best example I can kind of give to this is if any of you watched American Sniper, Chris Kyle in the movie comes back, he's stateside, they're having a picnic out back, the dog's barking, but Chris Kyle believes that the dog's about to harm his daughter and everyone else there. And he's choking this dog to death. In his reality, this dog is there ready to kill everyone. His wife's screaming at him, Chris, what are you doing? Chris. And it brings him out of it, and all of a sudden he's in everyone else's reality, where the dog posed no threat to anyone. And that's the best example I can give to someone who hasn't found themselves in that situation as to the difference someone would be going through and basically an alternate reality that they are in and out of. And it's not something that can't be gotten over, but you're going to need that medical assistance through psychologists, psychiatrists, and things of that nature. So that's why I'll tell everyone, if there's any way that you can just let law enforcement deal with it, do it. It's to your benefit. If they're grabbing your TV and they're on the way out your front door with your TV, I don't care if you don't have insurance to cover that TV. I can tell you it's far cheaper to replace that TV, even without insurance, than you using lethal force in that situation, even if if you are authorized to use it. So just keep that in mind. Is something I talked about initially. An individual is to be presumed, and you'll see the word presumed is italicized. This is on page 18. To be acting reasonable in the use of deadly force. Why do I have that word italicized? Well, what's important to understand is the law says it's a presumption that that individual intends you serious bodily harm or death. So what's a situation where the presumption may not apply? Well, let me give you an example. Let's say Jim lives down the street from you. You loathe Jim. Jim's an asshole. You would love an opportunity to off Jim. And one morning, 3 a.m., you wake up and you hear a noise downstairs. You grab your gun, you go downstairs. There is Jim, drunk off his ass. You know Jim doesn't have any idea where he's at. Jim thinks he's in his own home. In fact, Jim's naked. And you say, this is my opportunity to go off that SOB. And you shoot him. If the district attorney could prove that you knew that Jim posed you no risk or threat, he could basically challenge that presumption. So that's the type of situation that could result in a challenge to that presumption. To my knowledge, since 2014, when we've enacted the enhanced Castle Doctrine, there has not been a situation where a district attorney has attempted to challenge the presumption. It's going to be pretty difficult, and if you comply with Josh's rules 1 and 2, but mostly 1, don't speak to police, it would be pretty hard for them to prove that you knew he posed you no risk unless you talked with police. So just be cognizant of that. There's always a possibility in a way, but generally speaking, 90% of criminal defendants end up being convicted based on their own statements versus the actual evidence that the Commonwealth or federal government has. So bear that in mind. So now let's talk about our stand your ground doctrine. So this is going to generally apply anywhere the Castle Doctrine does not apply. So what does it provide? We're on the bottom of 19. An individual has no duty to retreat in public and has the ability to use deadly force, provided that, first, the actor is not engaged in criminal activity. I'm going to go through these and then we'll come back and talk about each one specifically because there's some that deserve a little bit of discussion. So again, first, the actor is not engaged in criminal activity. The actor is not in illegal possession of a firearm. The actor is attacked where Pennsylvania would have previously required them to retreat. The actor believes it immediately necessary to protect him or herself against death, serious bodily injury, kidnapping, or sexual intercourse by force or threat, and the person against whom force is used uses or displays a firearm or replica thereof or any other weapon readily or apparently capable of lethal use. So let's talk about these one at a time. So the actor is not engaged in criminal activity. As we talked about before, we don't want the gangbanger, drug dealer, yada yada, being able to claim stand your ground. 2, the actor is not in illegal possession of a firearm. We don't want a prohibited person being able to contend that they're entitled to stand your ground. 3, the actor is attacked where Pennsylvania would have previously required them to retreat. It's, in some regards, it's stupid that the General Assembly included this because all it means is everywhere except for where your castle is, stand your ground applies, which is what would happen no matter what, even if it didn't say that. So that's why I say it's kind of a factor that really has no analysis in the law. 4, the actor had the right to be in the place where attacked. Now, this is the one where I come back to what I mentioned earlier about locations that maybe have no gun signs or have no gun policies. If the district attorney could prove that you knew that this location was a gun-free zone and you decided nevertheless to ignore it, at that point, stand your ground would not apply to you. What would occur would be we would actually resort back to our duty to retreat law, where if you could retreat safely, you'd have a duty to do that. So let me give you an example of how this could play out. Let's say you go to your local mall and you're not too good at concealed carrying, and one of the security guards sees you and comes over to you and says, "Hey sir, I'm sorry, we have a no guns policy here. You're carrying a firearm, you're not allowed to be here." And you say, "Oh, I'm sorry, I'll leave immediately." "Well, that's okay, sir, but I need your name." And they write down your name. "Hey, no, I won't give you a problem, I'm just gonna leave, I'm sorry." And 6 months later, you are back at that same mall, and you're carrying a firearm, again, concealed. This time you've learned how to properly conceal it. No one can see it. And an active shooter comes out of that Arby's over there. Well, if I can retreat safely, I have a duty to do so. This situation, close proximity, probably don't have an ability to safely retreat, so I would be authorized in using lethal force in that situation. However, if the Arby's is on the other side of the mall, and right here is an exit, and I can go right out that exit without any concern for my safety, I would be legally required to do that. Now, in this day and age, if there's an active shooter, even if they could prove that you knew you had no legal right to be there and so stand your ground didn't apply and you had a duty to retreat, but you were able to neutralize the threat, I don't know that there's many district attorneys that would be looking to prosecute you. If you're in Philadelphia, probably. But some of you may remember, I guess it was now, I don't know, maybe a year and a half ago or so, the mall incident with the food court where some gangbangers got into an altercation, start shooting. One of the individuals, a good guy with a gun, pulls out his gun, shoots at them. All of a sudden, the next day, the media completely forgets about the gangbangers who could have killed people. And now they want the district attorney to prosecute the law-abiding citizen who was trying to defend everyone's rights, the good guy with the gun, because he was violating the mall's policy. And there was significant pressure. No one wanted to talk about the gangbangers who could have killed people. Now it was all the good guy with the gun. He was violating the mall policy. They don't talk about the gangbangers who were violating the mall's policy. Now it's the good guy with the gun. Thankfully, the district attorney didn't end up prosecuting that individual, but that's how these types of situations can come about. And you need to be aware of it and the possibility. This is why it's so important that you not speak with police or anyone else in a situation like that, because if you innocently say, "Well, yeah, I saw that no gun sign when I came in," or that, handgun with the slashy sign through it, well, you just admitted to knowing that they were a no-gun zone, and you were in violation of it, so stand your ground is not likely going to apply. So keep that one in mind. Yes, sure.
Your family's in the yard. You can leave, your family's in the yard.
So we're going to talk about that in 1 minute with third parties. So 4, we already talked about 5, the actor believes it immediately necessary to protect him or herself against death, serious bodily injury, kidnapping, or sexual intercourse by force or threat. That's all pretty clear. As long as the actor believes that they need to protect themselves from some sort of serious bodily injury or harm, they would be authorized to use lethal force, provided that the 6th element is met. And that is the person against whom force is used uses or displays a firearm or replica thereof or any other weapon readily or apparently capable of lethal use. And I know what every one of you wants to know. What are those weapons capable of inflicting that lethal use? Readily or apparently capable of inflicting that lethal use. It really is going to depend. We don't know. There is no list of different items. So for example, we can all agree that a knife or gun is going to meet the criteria. In fact, it already specifies that a firearm meets that criteria. Baseball bat, clearly capable of inflicting serious bodily harm or death. What about if you're up against Jackie Chan? I argue that his hands are lethal weapons in comparison to mine. But the law doesn't say definitively that that's the case. And that's likely a situation that's going to end up as a jury decision if the district attorney decides to prosecute. What about what we refer to as disparity of force? What happens when you have two people on one? Does the fact that there's that disparity constitute them being able to use lethal force against you, basically?
Yes.
Well, the law isn't that clear. What about where you have the 250-pound man against the 90-pound woman? I'm going to argue his body is capable of inflicting that serious bodily harm or death, but the law doesn't specify explicitly that that's the case. So you need to be aware that there are these situations where you may end up having to argue these issues before the court, and there is no clear outcome to any of them. There have been attempts made to add to the law, especially with disparity of force in situations like that, but again, because we haven't held the governor's mansion in a while, we haven't been able to get any of those additional laws passed to give additional protections to those who end up using lethal force. So be cognizant of this. I will also say that de-escalation techniques, in my opinion, are something that need to be trained more. Few people really train them at all. But, I'll tell anyone, if you leave any type of situation, altercation, regardless of whether a firearm's out, knife's out, or anything of that nature, alive, you're light speed ahead of yourself, because not one of us know what the outcome. It doesn't matter how much you train, it doesn't matter what your skill set is. We all have bad days. The bad guy may be having a good day too. So, being able to de-escalate and walk away from a situation, even if you gotta throw your pride under the bus, do it. It's the best way for you to potentially survive that interaction. So now, moving on to the right to use parties, this gets to your question. So an individual has no duty to retreat in public and has the ability to use deadly force to protect another person, provided that 1, the actor would be justified in using such force to protect himself against the injury he believes to be threatened to the person whom he seeks to protect. So basically, if I step into their shoes, I would be authorized in using lethal force. Then I've met the first criteria. Under the circumstances as the actor believes them to be, the person whom he seeks to protect would be justified in using such protective force. Now, this is important because it's what I believe the reality of the situation to be, not what the reality may actually be. So let me give you an example. Let's say you're in a Walmart parking lot and you're just getting out of your car and you see this guy kind of crouching down behind the side of a van, and there's a young lady walking kind of towards that van, and you see that he has a bat, let's say a baseball bat, in his hand, and you say, he's about to try and kidnap her or assault her in some way. And just as she breaks the plane of that van, he jumps out. Well, in your opinion, he may be ready to kidnap her or cause some serious bodily harm or death to her. He has a weapon, and you decide to shoot him before he can harm her. Well, what you didn't know is they know each other, and he was just playing a prank on her, trying to scare her. What the law would say is we look at what his understanding was, not what the reality of the situation was, not the reality of him just the other person playing a prank on the young lady, but what your observant understanding of the situation was. And that's really important because there are all too many occasions where someone gets involved in a situation believing they know what has occurred already or what's occurring currently, and they're mistaken. You come over someone who's just been shot and you see the guy with the gun and you think he's the bad guy. Well, little do you know, the bad guy's the one on the ground, but now you just shot the guy holding the gun. Because your reality of the situation was this person was robbing the guy on the ground who has a gunshot, and you thought you needed to protect him. That's why it's so important that the law actually would protect you in that situation, provided that it's a reasonable belief. And then the last one, the actor believes that his intervention is necessary for the protection of such other person. And again, it has to be your reasonable belief. Now, we have a couple minutes, so I want to walk you through a scenario. And this is just like one of probably a couple dozen scenarios you should have if you do carry on a daily basis. And it amazes me that few people actually do this. So the scenario is you're at your local burger joint with your family. You just got done at the range, you put some lead down range, and you're all hungry, and you're there looking at the menu from afar, and a perp comes in and sticks a gun to the clerk's head. What do? Oh yeah, by the way, these are all rhetorical questions. I don't want anyone in the audience to respond how you would respond. This is just to get you to think through them, all right? No one in this room can judge you for the decisions that you would make. So again, you're there looking at the menu with your wife and kids, spouse, kids, and perp comes in, sticks a gun to the clerk's head. What do? Time's ticking. Does your loyalty rest with your family to get them out into a protective state? Or does your loyalty rest with that clerk? Oh yeah, by the way, that clerk has a 3-month-old little baby girl that's waiting for her to come home that night. Time's ticking, what are you gonna do? Bang! She's dead. You took too long. You need to have already thought through this and what you would do, not find yourself in the situation and then decide how you're gonna respond, because you only have seconds. So let's rewind. Again, perp comes in, sticks the gun to the clerk's head, what do? Let's say you decide your loyalty rests with your family. No one in the room can judge you for that decision, and you can get them out to safety. You do so. Okay, now what? Are you going back in to protect that clerk? Because if you do, well, little did you know that there's a getaway driver. And they all agreed no one was leaving there alive. So did you just leave your family out back, unprotected? Well, if you planned for this, probably not. Maybe your spouse also carries a firearm or other weapon capable of defending the other family members, the children, or things of that nature. Depending on the situation, maturity of the children, maybe you've already trained for what we call dispersing into the wind, where if there's multiple aggressors, you all go in different directions so that there's hopefully an inability of all the aggressors to follow all of you, so that hopefully some of you will survive the interaction. Again, this is going to depend on a number of factors and you actually preparing for this possibility. Let's say you decide you're going back in, you want to save the clerk's life. Now would be one hell of a time to decide that you have a belief against taking another person's life. And trust me, there are some in our society that no matter what, for example, the Amish, you can be about to kill them and they will not, even if they have the ability, they will not take up and kill you. And so there are some with moral, ethical, religious beliefs that preclude them from taking another life. I can tell you that if you find yourself going back into that burger joint and then realizing that you have an ethical, a moral, a religious preclusion on taking another person's life, the one person that's going to end up dead is you. You should have already thought that through. Let's say you don't have any ethical, moral, or religious preclusion on taking another person's life. You go in there, perp's still got the gun to the clerk's head. Well, what are you going to do? Are you ready to take that person's life? Let's say you are. You pull that trigger, and little did you know, your last round at the range, you actually had a squib round. And that projectile is actually lodged in your barrel. And you just pulled the trigger, and now that new projectile hits that projectile that's in the front of your barrel, and it causes it to come out just on a slant, and you kill that clerk. Are you prepared for that possibility? Because it's there. It doesn't matter how much you train. There is always the possibility that you could end up taking that clerk's life. Remember, she also has that 3-month-old little baby girl that's waiting for her to come home that night. Let's rewind. Perp's still there with the gun to the clerk's head. And this one really amazes me that more people don't talk about it. What happens when that perp turns towards you and it's your son, it's your nephew, it's your uncle, it's your aunt, some family member? Are you prepared to use lethal force against a loved one? And if you tell me, oh, Josh, hold on, line in the sand is there and you just crossed it, that's fine. But also understand that that person may have no problem saying, oh, Uncle Jimmy, bang, yeah, where's that cash? Now, you could, let's rewind. This time, let's say, pull the trigger, kill the perp, clerk is alive. Most justified shoot ever. Next thing you know, you're being criminally prosecuted by the district attorney. It's a possibility. All of these are possibilities. You could end up spending the rest of your life in jail because you tried to do the right thing. And you have to understand that not one of us can control how any of these events are going to unfold. But you need to prepare for the possibility of all of these different outcomes being possible. Now, from doing this for a long time, a lot of people always ask, well, I'd like to know what other people think. And I always tell them, it doesn't matter what anyone else thinks. You have to make a decision for yourself and what's right for you in your situation. That being said, I've always told people, I have no problem saying what my general mantra is. And basically, it's simple for me. If I believe there's any possibility that I can save another life, I will do everything in my power to save that life. And the reason for me is that I know I wouldn't be able to live with myself knowing that I had a possibility of saving that life and I didn't take that opportunity. That doesn't mean it's right for a single person in this room. I know that in doing that, I could end up being forced to take a loved one's life. I know I could end up inadvertently killing the clerk and preventing that 3-month-old from ever seeing her mother again. I know it could be the most justified shoot, and I could end up being prosecuted and convicted by a jury of my peer. I know I could end up spending the rest of my life in jail. But yet, time and time again, I'm going to make that same decision because I wouldn't be able to live with myself knowing that I had that opportunity and I didn't take it. And I know this is much to the chagrin of my wife. When we were dating in that, she would come to seminars like this and she'd understand it. And she said, after we got married, she said, you're still doing the same speech. And I said, yeah. She's like, well, your loyalty is now with me. Why are you going in to save the clerk? Why are you, good? And I said, I understand and I respect that. But what I don't think you understand is you want me to come home. That's your underlying rationale for me not going in to save the clerk's life. If I believe I have an opportunity to protect that life and don't take it, I am not going to be the one coming home to you. Because I know who I am, and I'm going to be constantly reliving the fact that I had an opportunity to potentially save that life and didn't take it. And that's why I say, these decisions are not, no one in this room can judge you for whatever decisions you make. And in fact, I tell people this is one example of many, and just because you review it once doesn't mean you can say, okay, that's good, I know how I'm going to respond now. No, you have to review them with consistency, because things change. For example, we get married, we have kids, we get older, we're not as nimble. There are 1,000,001 different factors that occur to every one of us in our life that can change how we may respond. And it's okay to decide initially, I'm going to do everything in my power to save someone's life, and 10 years later say, you know what, it's a little harder for me to run and walk right now. I think, my biggest concern is going to be protecting myself first and foremost, and, I'll leave it to law enforcement for anything else. That's fine to make that decision. Just understand what all is at play in any decision you make. So with that, We have a couple minutes or so. I'm always happy to play Stump the Chump, so feel free to ask questions about anything firearms law related. You don't have to keep it limited to what's in the handout or what we discussed tonight. So we got any questions?
How about carrying on rails and trails, either owned by the state or privately held?
So the question is on any trails or things, whether owned by the...
Rails to trails.
What rails to trail, it's on like a mobile train type device or? Okay, so regular trails that you can ride bikes and all that.
Whether being licensed to carry, either carrying outside waistband or carrying concealed.
So if it's government owned, non-privately owned, again, there's no preclusion on you pursuant to a valid license to carry, carrying a firearm, whether openly or concealed. The one issue without the license to carry is that parks and those things are not specified as locations that you can transport a firearm to per section 6106. So that's why I would say, you need to have your license to carry, and then you can both open or conceal carry on any of the property that's owned by the state or local form of government. If it's truly private property, then that private property owner can regulate it as they see fit. Yes, sir. In the white shirt. Hold on one second.
If you're stopped by any law enforcement, do you have to tell them that you have a gun on you?
So the question is, if you're stopped by law enforcement, do you have to disclose that you have a firearm on you? Here in the Commonwealth, you do not. There is no legal obligation to notify law enforcement that you have a firearm on your person. I will say that if you're stopped by law enforcement, let's say for speeding or something like that, as a general rule of thumb, historically I've told people, because you have no duty to disclose it, don't disclose it unless you have to go to a location where the firearm is at, or you're asked to get out of the vehicle and the firearm's on your person. So what I mean by the first criteria is, let's say you keep your gun in the glove box, and you also have your insurance information there. If you're going to have to produce that insurance information, what I would say is, with your hands on the wheel, officer, I have my license to carry firearms. You're telling the officer that you know what the law is and you're in compliance with it. Officer, my firearm is in the glove box, or maybe it's appendix if they're asking you to get out. You're giving the officer that information as to the location of the firearm. Officer, how would you like to handle this so the officer feels in charge of that situation? I can tell you that over the past several years, the training for law enforcement seems to have changed, because I'm finding a consistent response from my own experiences as well as client experiences, where you disclose to an officer that you actually have a firearm on your person when you're pulled over and don't need to. And usually it goes something like, officer, listen, I have a license to carry, I have my firearm concealed appendix, how would you like to handle this? And law enforcement officer will say something akin to, well, you leave yours there, I'll leave mine here, and we'll both have a great day. So it seems to be that some newer training has kind of been rolled out in that regard in the past couple of years, but as I said, there is no obligation to notify law enforcement that you're carrying. Now, certain law enforcement computer systems, newer age ones, in their squad cars and that, are linked to a newer database that the Pennsylvania State Police has basically integrated license to carry firearms applicant information and driver's licenses. I believe it's actually unlawful, because all license to carry firearms applicant information is confidential, it's not subject to disclosure, and it isn't related to a law enforcement reason at that point in time to know that information. But nevertheless, the PSP has done that. So jurisdictions that have the newer computer systems, most law enforcement is going to know if you're the vehicle owner, or whether you have a license to carry, or even if you're not the vehicle owner, when they run your driver's license, they'll know that information.
Can they ask you to hold your gun until they're done with the stop?
So the question is whether an officer, for officer safety basically, can ask to retain your firearm. Under the law, they are, for officer safety, allowed to take possession of anything that could cause them serious bodily harm or death. Typically, though, again, most law enforcement officers that have been around for a while are just going to say, just don't make any quick furtive movements towards that location where you have the firearm, and we'll all be good to go. That being said, I've seen a number of younger officers negligently discharge firearms. They'll frequently try to unload them, especially derringers. I don't know what's up with it, but I know so many law enforcement officers that have negligently discharged a derringer by a roadside because they decided that they thought they needed to unload it. If they just left it in the possession of the owner, there wouldn't have been an issue, but there is no requirement. Sir in the green.
What do you think about is there a possibility to be a federal concealed carry?
So I assume you mean national reciprocity. Obviously, there's a possibility of it. Trump in 2016 had talked about it, but then it never went anywhere. It's going to depend if Congress is going to decide to push it through, and thereafter the president signed it into law. Under the current administration, there's no possibility of that. So it's really going to depend on that, but it is definitely a possibility, and actually already exists in relation to law enforcement officers and certain former law enforcement officers. There's something called LEOSA that applies to them, and they can actually carry throughout the United States if they are LEOSA certified. Yes, sir.
Conservative talk radio, they talk a lot about these burner launchers. Do they fall? It's a non-lethal kinetic round burner, BYRNA.
Okay.
Does that fall under the same stuff
So first and foremost, one of the issues I always have concern over is a lot of these companies that come out with non-lethal, what they claim are non-lethal weapons, never get approval from ATF. And there have been situations where items that have been marketed as being lawful actually are not. And when you have a barrel diameter over a ½ inch, you can get into objects that constitute destructive devices, things of that nature. And there have been situations where we've seen certain of these non-lethal projectiles be determined by ATF to basically constitute a destructive device or other similar type of thing. With those specifically, I don't know that ATF has issued any decision. I believe the size of them, though, is under ½ inch, but don't quote me on that. There is always, an issue. Obviously, using non-lethal is better than lethal, unless you need it lethal. I always tell someone, if you're pulling your firearm, it's because you believe your life is in danger and you're prepared to use lethal force. So, I know there's some that'll teach, shoot to maim. That's the most ridiculous thing I've ever heard. If you, believe that you have fit the criteria for stand your ground or castle doctrine, depending on what the situation provides, and you believe your life's in danger, you use lethal force.
Second question. Where are you doing your next 4-hour course at?
Trop Gun Shop, I believe it's in September, in Lancaster. Yeah. Any other question? Yes, sir.
I got busted for a marijuana charge 45 years ago.
Okay.
I moved to this state in 92, New Jersey. 93, I put in for a permit, and they gave it to me. I went to renew it. They said, no good.
You went to where?
Renew.
To renew.
To renew, yeah. And they said, no, you can't renew, you have a marijuana charge. Now, that marijuana is legal in New Jersey. Recreation marijuana is legal in New Jersey. Does that still hold you up here?
So your issue is actually several different ones, honestly. First and foremost, the preclusion on obtaining a license to carry is if you've been convicted under our Drug and Cosmetic Act. So if you were convicted in New Jersey, provided you were not otherwise prohibited from being able to purchase, possess, utilize firearms and ammunition, you were probably erroneously denied renewal. Now, what we need to know is when you were convicted in New Jersey, you could have been punished by. Not what you were, but whether you could have been punished by that more than 1 year in jail. And if so, then you would be prohibited from purchasing, possessing, utilizing firearms and ammunition. The other issue to be aware of, and I am not licensed in New Jersey, is whether you might be able to get expungement or a pardon. A pardon is probably pretty difficult in New Jersey, not necessarily here, but whether you can basically get relief from that conviction, because that might be an alternate option for you.
That's legal now, right?
Well, that doesn't mean that they undid their convictions for it previously. They may have, they may not have. I would suggest, in relation to that, you can always contact Evan Knappen. He's a phenomenal firearms law attorney in New Jersey.